The next matter, Your Honor, is number 9, the matter of Theodora Antar and Matthew Lodice.
Thank you.
Paper is filed.
Thank you, sir.
All parties, please raise their right hand. Does everyone solemnly swear, sincerely affirm the evidence they're about to give be the truth, the whole truth, nothing but the truth? So help you God or upon penalty of perjury.
I do.
Thank you. Ma'am, sorry, would you please state your name and address for the record, please?
Theodora Antar, 856 Shadowburg Drive, Orange, Connecticut, 06477.
Thank you. Sir, your name and address?
Matthew Lodice, 23 Lyman Street, New Britain, Connecticut, 06053.
Thank you. And for support enforcement?
Dawn Morrow, Support Enforcement Officer, New Haven, Connecticut.
Yes, ma'am.
Your Honor, I believe that there's several motions on today in this case. There was a contempt that was continued from March 9th to today's date. And then both parties have filed pro se motions to modify. And then I believe that there's another motion that family court referred over.
There's an order today from Judge Grossman, Your Honor. It's the last order. I just see it's new in my queue.
Thank you.
You're welcome.
Number 136 is support enforcement's contempt. Is that correct?
Number 136, you said, Your Honor?
136.
Yes, Your Honor. 136 is state filed.
Is 137 also before the court today?
I have 136 and 148, Your Honor, on my docket. And then there's a 146.01 and a 152. Those, I believe, are the mods. Excuse me, 152 is a motion for order of some sort. Financial discovery order, Your Honor.
Maryland's order of 4/12/2022, based upon the agreement of the parties, has deferred to the Family Sport Magistrate Court the outstanding motions number 142, 146.01, number 152 for hearing on 6/1/2022. Further, it says the defendant shall re-engage paying child support to the plaintiff. The defendant is the gentleman, I presume. $120 per week on Friday by 6 p.m. starting this Friday, 15/2022. And apparently that was that April, sir?
Yes. I want to say it was the 12th.
And the final amount is subject to the decision of the Family Sport Magistrate hearing on 6/1/2022. First to you, ma'am. What motions do you believe are before the court today?
So the clerk's office stated to me that the defendant's motion 142, which was motion for modification, which you stated was originally set for this date, was moved to the June 28th hearing in front of family court because that one is strictly only about custody. So, and
Can you
also,
verify that?
I spoke to the supervisor.
Please.
Okay.
Sir, 142 is your motion, is that correct?
Is that the custody? If it's the custody one, yes.
Okay. Is it correct that's going to 6/28/2022?
That I'm not sure of.
Okay. Do you know if that's going before the Superior Court judge?
I believe it is.
Yes?
Yes.
That's not a child support issue, correct?
Well, when I called yesterday, they told me we were seeing all those matters today, so I'm a little bit confused.
No, sir.
Okay, so that's the 28th. So yes, I understand that.
Okay. So 142 should have a court date of 6/28.
It does, Your Honor. I can confirm, Your Honor.
And that's in the Superior Court?
That's what the Superior Court, I believe, Bryce Borland.
Thank you. So that's off my docket today.
It's with Judge Grossman. I apologize, but it is off your docket. Yes, Your Honor.
146.01. Ma'am, this is your motion to modify regarding child support and or visitation, right?
Correct.
Can you tell me if that motion 146.10 is also in the Superior Court regarding visitation?
I was told 146.01, the child support portion would be heard today, and any of the custody issues would be heard in family court.
And you have a date when that's going to be heard?
6/28.
Also on 6/28?
Correct.
Okay. $152. And 152 is a motion for discovery, is that correct, ma'am?
Correct.
And have you served the gentleman your discovery request?
I was told to send a certified copy, send a copy to his address, and that wasn't required to be served. there was never anything sent back to me by the court to have it served. They stated it would be heard at the hearing.
Has the court acted on your motion for the financial discovery?
I was told it would be, the decision to act on it would be done today at this hearing. This is our first time coming to court since I filed.
And is that with regard to your pending motion to modify?
Correct.
Okay. Sir, do you have a motion to modify on today?
I do.
Can you tell me the number for that?
I don't know.
Mr. Clerk?
Your Honor, it should be on the docket.
Is it number 148?
So, for our court, Your Honor, what's on today is 136 contempt and 148 mod. There are other mods, specifically 146.01 and 152. But as far as I know, those are set down to be heard on June 28th in family. But I do note that it does deal somewhat with support as well.
Sir, is 148 your motion to modify?
I don't know it by number, sir.
Okay.
Your Honor, 148 is the plaintiff's motion. Try to find.
Does the gentleman have a pending motion to modify?
I'm going to try to find it for you right now, Your Honor.
Thank you.
Just look at 146.01.
That's
Right, but I don't care what it says, PRD, just,
no, we already looked at it already. It's that one's going to family court.
right, but who filed it?
She did.
Okay, so she filed that one, so go to now 152.
That's the motion we just looked at for financial discovery. That's hers.
Okay, then go to info 2. And just control F. Let's see what other mods there are.
Right there. What was that?
No, that's way up. That's earlier. Right here.
That's hers.
Mr. Clerk,
Yes, Your Honor.
take a look at 148 and 146.01 together.
Yep. So 148 is her mod that we scheduled here. Yep, that's what's on the docket today. And then 146.0.1 you said?
Yes, sir.
It's the same motion.
Right, but so the reason that they're the same motion is we scheduled the custody parts down in Superior Court and then support down here in ours. So
Okay. So which motion's in the court? 146.01 or
so
148?
148 is the one we are dealing with.
Okay. And 146.01 is 628.22.
Correct.
Superior Court.
Yes,
Correct,
sir.
Your Honor. Yep.
Regarding the visitation. So you use the same, just so for the record, you use the same pleading with two different pleading numbers to split them between the courts.
Correct.
Okay. Does the gentleman have a motion to modify on today?
Most of these motions that I see are filed by mother. I do not show mod from father.
My modification was filed along with my child custody. I applied for custody, modification of everything all in the same filing.
Do you know about when that was? Was it in 20?
March 7th or 17th, around that day.
Your Honor, I think he's referring to contempt 140.
Okay, let's look at that. The pleading is a motion for contempt by the gentleman. Was that acted on?
That was all the same day.
Was it acted on?
I don't believe so.
Your Honor, that was scheduled in Superior Court for April 12th. From what I show, it was in front of Price Borland, and it's resulted as event completed, but I'm not sure what happened with it.
So do you have a pending motion to modify for the court today, sir?
I probably did, but you guys are telling me no, so I would assume no then.
You have a copy of your motion?
I do not with me. It could come
Ma'am, did you get served? Ma'am, did you get served by the gentleman a motion to modify?
No, I did not. The only motion that he filed was a motion to modify custody, which I also was never served with. He never filed a motion for child support modification ever.
And sir, you have no proof of proceeding today on a motion to modify regarding the child support?
May I have 1 moment just to look at my paperwork? Thank you. This one's
You have 152 on for the discovery motion in front of the Superior Court.
Yes, Your Honor, that on June 28th.
June 28th, yep.
Yeah, I do not.
You have not filed, sir?
No, I do not have proof of me filing.
Okay.
I did file, but I don't know where my copy is. I don't have it on me right now.
So the only motions for the court today is 136 under the contempt and 148 petitioner's modification.
Your Honor, I was told 152 was being heard today in front of magistrate because it involves child support. The family.
I have my two clerks standing to my right, and they're telling me that 152, the discovery motion, is on for 628.
Yeah,
We checked with the family clerks on this because there's so many motions filed, Your Honor. 152 was guaranteed that it's going to be heard in family court
and
on the 28th.
and additionally, Your Honor, we did find the mod that Mr. Lodice is referring to is 142, but that was also put down for that April 12th date in family court.
Strictly custody also, Your Honor.
Okay, give me that number again.
142.
42.
Yeah, it'll be 141/142. Excuse me, Your Honor.
Okay, let's look at that. Everyone writing these numbers down?
No, should we?
We actually had, that's how we figured it out in the end, Your Honor. We had to write them down. There were so many.
Yeah. Motion to modify by the gentleman is number 142, and that's with regard to apparently custody or visitation, not child support. Nothing checked under the boxes regarding changing the existing orders for child support under subsection small a. It was with regard to father becoming the custodial parent in full custody, not before the court today. So the only motions before the court is 136 and whether it's 148.
Correct, Your Honor.
Thank you. You want to be heard on your modification first, ma'am? Parties under oath?
Parties are under oath, Your
Anyone
Honor.
about thank you? Parties under oath?
Parties under oath, Your Honor.
Thank you. Ma'am, you go first under your motion to modify.
Well, the clerk's office prior to this told me that the 152 was being heard today, so I'm just a little confused because I was told that anything to do with child support was having to be heard in magistrate and not in family court. So are you guys now saying that it's 100% going to be heard on the 28th and not in front of this court?
What, ma'am?
The motion 152 for financial discovery regarding child
My
support.
clerks are informing me, motion for discovery 152 is scheduled for 6/28/2022, Superior Court.
Okay.
Are you proceeding on your motion to modify today, ma'am?
I'm asking if we can have a continuance on that to wait for discovery to come in because his financial affidavit is extremely lower than what he's actually making, and so I want to wait
What
until
date would you
discovery
like
comes
your
in.
motion to modify continue to?
After the 6/28 hearing when the financial discovery motion can get heard.
Any objection to her request for continuance on the motion to modify?
No, Your Honor.
Okay. What
Well,
day?
actually, yes,
Hold
Your
on.
Honor.
What
I'd like to
day?
object because I don't make the money I was making
No,
when I
it's
originally.
not an issue. We're
Okay.
not discussing the merits. We're
Okay.
discussing the request for a continuance, not the merits.
So yes, I object to the continuance
Why?
because I don't have the money I was making then. So without
We're
modification.
not discussing the merits of the case today.
But you asked me why. Okay, then I guess not.
Do you think your motion will take more than an hour?
For the modifications?
Yes, ma'am.
Yes.
Okay. My clerks, you still do special hearings on Mondays?
We do, on the second, fourth, or fifth Mondays of the month.
May court date after 6/28, it's on a Monday for a special hearing with a time block for these parties.
Right there, 7:11.
7-Eleven, Your Honor, 10 a.m.
Let's verify that that's good for the parties first.
Not 10 a.m., it's a special hearing, so we have to make sure it's not already taken.
Okay.
So 10 a.m. is already taken, Your Honor, so we can do 2
2
p.m.
p.m.
On which date?
7-Eleven.
Ma'am, July 11th at 2 o'clock, is that fine?
That's fine.
May I just check my calendar real quick, my phone?
So on special hearings, it's 1 meeting. Special hearings, like that one, it's not a calendar call or anything.
It's fine. It's perfect.
Okay.
2 p.m.
2 p.m. on motion 148, which is the petitioners, over to special hearing date July 11, 2022 at 2 p.m. As to the contempt, is that support enforcement's contempt?
I believe it was, Your Honor.
Yes, Your Honor, it was filed by our office by Ms. Antar's request. And that was continued from March 9th to today's date for an update on the custody matter.
Can you tell me if the custody matter has been resolved?
Not to my knowledge, Your Honor.
Your Honor, I believe that that 6/28 date is a date where they're going to hear a bunch of things in family court from what I was told.
Yeah, and Ms. Morrow, isn't it true that Judge Price Borland has put a order on the gentleman?
Your Honor, Mr. Lodice was already under a court order to pay the $120 per week. That order had entered November 7th of 2019.
Mr. Clerk, what's the order from Price Borland, please?
Price Borland. Your Honor, the order from 4/12. It goes over many. Is there a specific?
It's pleading 153.1, Your Honor.
Thank you. You have a copy of that? Support enforcement? 4/12/2022 order by Judge Price Borland.
I do, Your Honor.
Defendant shall re-engage paying child support to the plaintiff $120 per week on Friday, 6 p.m., starting this Friday. And since it's dated April 12th, they meant April 15, 2022. And that amount is subject to the decision of the Family Court Magistrate on the hearing of 6/1, and the modification is now over for special hearing to 7/11. So under the contempt, what's your alleged period of time of noncompliance with the court order?
Your Honor, our contempt calculation went from when Ms. Antar requested our services, which was February 9th of 2021, to June 1st, today's date, June 1st of 2022, which was 68 weeks at the $120 per week, which would have been $8,160 that Mr. Lodice should have paid. He paid $4,285.53, which leaves him delinquent $4,034.47, which is also...
Why did Judge Borland write the words re-engage?
do not know, Your Honor. We had no knowledge that the order had ever been stopped.
Your Honor, may I answer?
Yeah. Is the court enforcement aware if at any time a Superior Court judge stopped the order?
No, Your Honor, I'm not aware of the order stopping it.
Anything else?
No, Your Honor.
Okay. Ma'am, do you have any questions for Support Enforcement Services? In the form of a question.
Are you aware that Judge Price Borland stated that she wanted him to re-engage in paying child support because he had stopped paying and hasn't paid since November of 2021?
We do have the last payment being December 6th of 2021.
And are you aware that the reason why she wrote in her order that he is to re-engage paying by Friday, April 15th by 6 p.m. was because I brought up in court at our hearing in front of her that he has not paid anything since December of 2021, and the reason why was so that she could order him to re-engage paying the existing order that he deliberately stopped paying?
I was not there.
Okay.
Any other questions out there?
No.
So do you have any questions for the Support Enforcement Officer? In the form of a question.
Okay. The number that you have that is owed versus what is paid, is the owed amount child support by itself, or is there other things added on to that, such as like hypothetical alleged daycare, babysitting, stuff like that?
No, the calculation that I gave is strictly the current child support order of $120 per week.
No further questions.
Ms. Morrow, any other testimony?
No, Your Honor.
What are you claiming is the amount of the delinquency?
Our calculations, Your Honor, is $4,034.47.
$4,034.
47 cents.
47 cents as of what day?
Today, Your Honor.
6/1. Is that all?
I apologize, Your Honor. If the delinquency is the same as the balance that's owed to Ms. Dantar, and that $4,034.47 is as of May 24th, 2022.
So the arrears is also the delinquency?
Correct, Your Honor.
And what's the period of time that
February
accrued?
9th, 2021, when Ms. Dantar requested our agency's services, to June 1st, 2022.
And when did that order enter for $120 a week?
November 7th, 2019.
And who entered that order?
Judge Cloud.
And was that order ever modified?
Not to my knowledge, Your Honor.
And that was by agreement of the parties, which was approved and incorporated by Judge Clark in his judgment, correct?
Correct.
Ma'am, any other testimony you want to offer the court today under the contempt?
Yes. So the defendant has not made any payments to support enforcement since the last payment that came in on December 6th, 2021. He has had the ability to pay during this entire time and deliberately refused to make any payments whatsoever. The defendant has a business, Whole House Remodeling Company, LLC, which he first established on April 16th of 2021. It's a construction remodeling company, which he is the sole owner of it. And he has stated to me that he's making more money than he's ever made in his entire life. He also stated that he made substantial amounts of money in the stock market in the last 2 years, which is all part of what I asked for in discovery here. Bank statements, statements from his retirement accounts, so on and so forth. He has 3 cell phones, which he keeps active. He has a line he pays for his 15-year-old son, along with the phone. He also has a business phone, and he has a personal line, all of which he pays all 3 of those. Previously, he was living with his mother until December of 2021 when he moved out and got his own apartment. He sent me several emails telling me that he wants me to see his new lifestyle, see the way he's living. He offered to have me come over for dinner, to come over for wine. He said that he wanted me to be back with him and kept telling me how much money he's making. During this time as well, I've asked him to pay the child support. He has his business, which he spent money on advertising for the company. Also, he has taken out advertisements, which he paid for the business as well in a newspaper. He's also publicly sent money to individuals for gambling and other recreational activities on Venmo. He also...
What's your objection?
My objection is she's saying things with no proof.
I have proof, Your Honor, and I'd like to submit.
You don't get to interrupt. I haven't watched it. Thank you, sir. What's your legal basis for the objection?
Hearsay. She's saying something with no evidence.
Hearsay would be an out-of-court statement offered for the truth of the matter from a third person.
Okay, lack of evidence.
Overruled.
Okay, so as I said, I have evidence of each and every one of these things. He also publicly donated money to a GoFundMe campaign for an individual, Jason, who actually overdosed from a drug overdose. And during the time when Matthew was refusing to pay his court-ordered child support over the last 7 months, him and his parents donated a total of $230 to the funeral fund of that individual who overdosed. He also
Basis of your objections?
My parents' donations have nothing to do with my donations.
So you're claiming it's not relevant?
It's not relevant.
Sustained.
I have evidence here. It says Matthew Lodice donated a total of $30.
That wouldn't be his parents, would it?
His parents are Karen and Roy Bowers.
His objection is sustained as to his parents' information as to what they donated.
Okay.
Move on.
Furthermore, he went to a concert, he publicly posted about a Tool concert, which he went to on February 23rd, which the tickets were starting at $122 per ticket.
Objection.
Basis of your objection, sir?
It was gifted from a friend. I didn't pay for it.
No, it has to be an objection based upon the rules of evidence, sir.
She's saying something that I'm paying for that I didn't. I don't know
You
what
can
you cross.
cross-examine her on that, sir.
Okay.
It's not a basis of an objection. Overruled.
Furthermore, he publicly posted about several jobs that he was doing, including video postings of him renting equipment from Home Depot, renting Home Depot tool equipment. He told me several times in emails that he is not going to pay unless being forced to do so by a judge. He said he said also that he does not have to comply with a court order and that nothing will happen to him and he cannot get arrested or get in trouble for violating a court order. In addition to that, like I was stating about spending a lot of money on advertising for his company, as you see here, $500 off projects of $3,000. These are flyers. He actually
Are you
paid.
offering the document, ma'am?
I'm sorry?
Are you offering that document?
Yes, I am.
Show the opposing party the document. Being offered, sir.
Objection. You want me to take it?
Well, you have to look at it, sir.
Oh. Yes, I know.
It's called a courtesy. She's offering it. She'd like the court to see it, sir,
Okay.
as a document and a full exhibit. Do you have any objections to that being marked as an exhibit?
No.
Okay, without objection. comes plaintiff's one.
Plaintiff's one, Your Honor.
Thank you. Please continue, ma'am.
So I also would like to enter this as an exhibit, which is the certificate of organization for his limited liability company, which was filed on April 16th, 2021, which lists him as the sole owner of the company.
Show the gentleman. Also offering that document, sir, any objection to that being offered?
No.
Being made a full exhibit.
No, this is accurate.
Plaintiff's two, Your Honor.
Plaintiff's two, Mr. Clerk.
Thank you, sir. Plaintiff's one. I was saying sir to him, not you.
Please continue, ma'am.
I also wanted to submit this as exhibit. I had requested for him to purchase some underwear for our child since I hadn't received child support in so long, and he stated that he was not going to be purchasing, he wasn't going to be giving me the money, but he then purchased it and had it shipped to our home via Amazon. This is the package that it came in. So I just wanted to show that he does have the ability to pay, but he will not pay child support directly. He'll pay for items and have them shipped to my residence for the child, but is deliberately refusing to pay the child support. And this is the tracking number information, which can be traced to see that he was the one who made that purchase.
You offering the document, ma'am?
I'm offering it, yes.
So, any objection to the offer?
Objection relevance?
How's that relevant, ma'am?
It's relevant because I asked him if he could provide me money to pay for the underwear we needed for our child. He refused to pay the money. He also refused to pay the child support and instead sent items to our home with the underwear. So he purchased and had it shipped to our home, but he is showing the ability to pay. I'm demonstrating that he has the ability to pay, yet he's refusing to follow the court order. And he was again ordered by Judge Price Borland in April.
So the proffer is that the document itself intends to show the court that he has monies in which to make the purchase.
Correct.
Sir, the document, is that an original document?
It's a packaging label. So no, it's not.
All right. Does it appear to be an original packaging label?
Yes.
Okay. And your objection is that it's not relevant?
It's not relevant. No, it's not relevant to.
Objection's overruled. Plaintiff's
Plaintiff's two, Your Honor.
I also have another document which is showing the listing of the apartment which he has been renting since December of 2021. He continuously was lying about his address.
Just identify the document.
The document is from hotpads.com showing the address 23 Lyman Street, apartment 3 in New Britain, Connecticut, which he currently is renting. And it's showing the price of $950 a
What's your
month.
objection to the document?
That's not my address.
So you're claiming that it's not authentic or correct?
It's not authentic.
Ma'am, what's your proffer? The
He
gentleman has
stated
claimed, for the purpose of the record, the gentleman has claimed an objection that the document which you're holding is incorrect. It's not valid, it's not accurate.
He stated at the beginning of this hearing that his address was the address listed here. And I also have, he's, in all of his prior motions, has listed this.
Show him the document.
This is for the upstairs apartment that was rented out to another couple. I live in the second floor
The
apartment.
document itself, sir, is it an original or a copy?
Of what? Of what it
Whatever she
is?
proposes that it is.
Yes. It is an document of what she's... It's the original copy of the third floor post, but not where I live. So yes, it is to the
And the
post.
offer made by her was that it's the address by which she reside at.
Yes, but that's not right.
Okay. Then the objection is sustained, it's ID only. Bring it in. ID only, Mr. Clerk.
Plaintiff's for ID only, Your Honor.
Thank you.
I have another document I'd like to submit. It's email communications between the defendant and I from March 7th of 2022. He stated no
Tell
money.
me what it says.
I'm sorry?
Just tell me that it's a document.
It's a
You can't read
document.
from a document not yet in evidence, ma'am.
Okay.
You have to just identify the document, tell me what it is, show it to the gentleman in the opposing party.
It's an email communication.
Thank you. He's offering the document, sir.
objection because it's incomplete. It's part of a conversation, not the conversation. So it's cherry picked.
Not the complete conversation?
Not the complete
It's
conversation.
only a part of it?
It's only a part of it.
Want to be heard?
Your Honor, that is
From me?
Your Honor, that is the complete, and also there is only one thing in there which I wanted to highlight, which is our communication on the first page. And that shows the whole full conversation to give context. However, I did want to mention on the first page there,
Is that the complete conversation?
it is. And I also have more copies of it as well,
More copies of the same conversation?
as it continued from the same day.
You have the complete conversation?
If I can see my paper, I can tell you he won't give it back though.
She can have it back. I have the full conversation here printed.
So the conversation here, the one that I'm showing,
As to your objection that it's not the complete conversation, sir, is sustained. You want to mark that, ma'am, only for that document, I'll mark it as ID. If you want to make a proffer as to the full conversation, you may do so.
I do, I have it right here.
Okay, show it to the gentleman.
This is the same paper.
Pardon, sir?
These are,
The full conversation is there. If you flip through the pages, you'll see it goes in order. It's printed from Gmail.
sorry, give me 1 second. And 16. Still not the full conversation, Your Honor. Objection.
Pardon, sir?
Also, it's still not the full conversation, so I still object.
It is the full conversation. I printed it directly from Gmail, and he has nothing to show otherwise that it's not. I printed that directly from my email communication, so him saying it's not the full conversation is completely correct.
I also have the printed email thread in its entirety, and the conversation ends at 9:16. Meanwhile, hers ends at 8:54.
When is yours in?
9:16 a.m. So there's also 1, 2, 3, 4.
Your Honor, he's not looking at it correctly. It actually shows everything there, and if he would let me see it, I can show you that it does. And also, I'm not referring to our communications after that, because none of that has anything to do with the financial issue.
Complete conversation, ma'am. He's objecting that it's not the complete conversation.
It is, it is. Can I please see my document?
If it's not the complete conversation, the objection is sustained. It'll be marked for ID.
I have this conversation which goes on until 9:06 a.m. I'm not sure what he's referring to, but again, if it's a separate conversation, it's separate from this one, which was starting at 8:40 a.m. on that day.
You offering it, ma'am?
I am. I'm offering this conversation which ends at 9:06 a.m., which is with the last thing that he said.
Okay, show it to the gentleman.
Yeah, I still object. It's still the same thing. The same
Overruled.
point.
Full exhibit and the conversation. The objection overruled. Full. Plaintiff.
I also wanted to show a documentation of a screenshot of him working and utilizing tools that he rented from Home Depot.
Any objection to that coming in, sir?
No, Your Honor.
6, please. Come
Out
out
of
here.
Your Honor. Plaintiff 6.
I want to show a check that he wrote out of his business account, which he also failed to disclose on his financial disclosure, for advertising that he paid for his company.
Any objections? No objection.
7, Your Honor.
Plaintiff
Plaintiff
7.
7.
I'd also like to show evidence of him making a payment to friends on Venmo on January 9th, 2022 at 1:28 a.m. for the pot.
Any objection to that, committee?
I have checked. There's no financial on that. There's nothing financial on that. It's
Your
just-
Honor, Venmo is actually allows you to publicly view when people send other people money. So it states Matthew Lodice paid
Tell me
Samantha.
what it says, ma'am. You
I'm sorry.
can't read from a document not.
It's a documentation showing evidence of Matthew making payments to other people during the time when he has not paid 1 cent of his court-ordered child support.
Objection, sir?
No objections. Just take it off.
No
I also
objection.
have another document I'd like to
Proceed.
give, which is proof of his payments to a GoFundMe campaign for the individual who passed away.
Objection because it has my mother's highlighted. I mean, just take whatever. It's fine. No
No
objection.
objection, sir. Without objection. Plaintiffs.
It's automatic.
I think there's 9 here.
9.
This is also showing the proof of the cost of the tickets for the event that he attended during the time.
Objection. That has no merit to this case. Relevance.
Your objection, sir.
Relevance.
How's it relevant, ma'am?
It's relevant because he posted on February 23rd.
Show me the document, ma'am. Explain it.
The document is relevant because it's showing that he has the ability to pay child support because the concert he attended started at $122.45 per ticket. And that's what this demonstrates
What's your
here.
objection,
There's
sir?
nothing there that says I paid for those tickets. So what does that price of the ticket matter?
I also have another
Objection's
document.
overruled. Mark it as plaintiffs. We can cross on it.
This document is also another from the same day when he was bragging about the concert.
10 here.
Thank you. Any objection, sir? 11, please, plaintiff.
11, Your Honor.
This is another email showing his ability to pay.
What's the document, ma'am?
It's an email communication.
Objection and relevance for this.
Crawford, ma'am. How is it relevant?
It's relevant because it shows his ability to pay.
How?
May I see
No,
the
don't
document,
make
please?
to question each other.
Oh.
Looking at a document, you've objected to it as it not being relevant. I asked her for her proffer as to how it's relevant.
Okay.
She says it shows as to your ability to pay.
Hey. But it doesn't.
Well, then you get to cross her on it. The objection's overruled. Make it a full exhibit.
12, Your Honor.
Thank you.
So I have another email of him asking me to go to dinner, to have dinner with him, which also demonstrates the ability to pay.
Alright, so I can eat. It's fine.
No objection, sir?
No objections, Your Honor.
Plaintiff's for.
13, Your Honor.
Thank you, sir.
Another email of him asking to set up a date, which is also showing the ability to pay.
I'll be able to cross-examine these, or I'll be able to cross-examine these, so, yeah, I have no objections.
No objection. Plaintiff's.
14, Your Honor.
Plaintiff's 14.
Also here, another email communication of him stating he's not going to pay and the deliberate refusal to pay.
This is fine.
No objection, sir?
No objection.
Plaintiff's 15, Your Honor.
Plaintiff's 15.
Another email showing evidence that he's been working this whole time.
What's What's the document, ma'am?
It's email.
Thank you.
That's fine. No objections. What numbers?
It's
Sorry.
gonna be plaintiff 16.
Plaintiff 16, full exhibit.
It's another communication in the Our Family Wizard app.
Any
No
objection,
objection, Your
sir?
Honor.
No objection?
No.
17, Your Honor.
Plaintiff 17.
Another Family Wizard communication app. Or copy.
Any objection, sir?
Plaintiff's 18, Your Honor.
No objection, sir?
No objections.
Plaintiff's 18.
Thank you.
This is another communication in the Our Family Wizard app.
No objections.
Okay. Plaintiffs,
19, Your Honor.
thank you.
Another Family Wizard communication.
No objections.
Plaintiffs 20.
It's another email communication.
Definitely no objections to that.
No objection, sir?
No, sir.
21. Plaintiffs, please.
This is a copy of Venmo payments that he has made, demonstrating his ability to pay.
Objection relevance?
Is that relevant,
It
ma'am?
demonstrates that he's had the ability to pay his court-ordered child support this entire time, yet in the past 7 months still refuses despite having the ability to pay.
This is all before she filed. This is me paying her.
Okay, the objection's overruled. Plaintiffs 22.
I'm sorry.
You can cross on it, sir.
Yeah, I know. Yeah, I'm sorry.
I also have another email communication
Wait,
demonstrating his
before she-
ability to
can
pay.
you read
22.
Sorry.
Any objection?
No objections.
Plaintiff
23, Your Honor.
22.
Another email communication showing the ability to pay and refusal to pay.
How many more documents do you have, ma'am?
I have a lot of documents.
Perhaps we'll take our lunch early and you can pre-mark them all for ID.
Yes.
Court takes its recess, pre-mark them, ID only at this time, and then you can introduce them.
Okay.
Sir, before we leave, in a contempt proceeding, you have the right to an attorney. You can ask for continuance if you wish to hire your own attorney. You can ask for court-appointed counsel if the court finds that you're indigent, subject to finding of contempt and the possibility of incarceration today. Or you can waive your right to an attorney and you can represent yourself. How are you proceeding? You can represent yourself, sir?
Yes, sir.
Doing so freely and voluntarily?
Yes, sir.
You don't make any threats or promises against you to do so?
No, sir.
Okay. The matter is passed until 2 o'clock. All your further documents, you're going to mark it starting at what number?
Starting at 24, Your Honor.
Starting at 24, they're all ID only. They have not come in yet. Pre-mark them.
Can I bring
Sir, you may have an opportunity through the support enforcement to take a look at any of the documents.
Okay.
Any of those documents that you do not object to will come in fully as full exhibits. Any that you do, we'll hold a hearing on them.
Will I have a chance to look at them after they get submitted?
They're not getting admitted, sir. They're being marked for ID only. You're going to get an opportunity to look at them.
Okay.
Any ones that you do not oppose will come in as full exhibits. We'll try and shorten this up. Any ones that you do, we'll hold hearings on them.
Thank you, Your Honor.
Thank you.
Your
Get them
Honor.
all pre-marked.
Before you go off the bench, are Attorney Kyman and I released, or would you
You
like
are.
us to remain?
I have one other matter, which is number 3. Is that being marked?
That's marking, Your Honor.
Thank you. Party's excused till 2 o'clock.
Thank
Get
you.
them pre-marked, ma'am.
Thank you.
Then we're going to have the gentleman take a look at each of those documents on the record.
Okay.
Counsel that's appointed, thank you for your services. Welcome to the board tonight. Court's in recess. You have them pre-marked?
Yes, Your Honor. They're pre-marked. However, Mr. Lodice has not finished reviewing all of them.
How much more time do you need?
I just started going through them at like 2:15 when she finished them.
We have
How much time do you need?
How many more are there?
uh, 29 more to look at.
Probably 15 minutes, I would assume.
How much time, sir?
I don't know. I don't know what the evidence is to read through it, so I would say 15 minutes.
Okay. Complete reviewing the exhibits that are being offered. The court will come back in at 3:15, and we're going to continue the hearing.
Okay.
Recess.
So we're 58.
All the exhibits that are pre-marked without objection.
These are non-objective.
No objection to those documents, sir? As pre-marked. Sir?
Sorry, sir.
No objection to the documents being offered that have been pre-marked.
Can you hear me?
Sure. Any objection to the documents that just came forward that were pre-marked?
No.
Thank you. So marked, full.
Thank you, Your Honor. Plaintiffs 24 through 76, Your Honor.
Thank you.
Thank you. Full, Your Honor.
Full. Any documents being offered that are presently marked ID that are objected to?
Yes, Your Honor.
How many?
There's 1, 2, 3, 9.
Fine. Take one at a time. Show them to the gentleman. I'd like to know the gentleman's objection to each of the documents. Give me the number on it, please. Marked for ID at this time.
This is ID number 26.
Relevancy and foundation.
What's the document?
It's a document of 2020 income, which has no relevance to this case, and foundation is where she obtained these illegally.
You offer that document, ma'am?
Yes, I did. That was not obtained illegally. I was actually the manager of that company, and I was able to get that because I was given access to it. And
What does the document indicate? What is the document?
The document is income from 2020, which is also relevant because this is our first time in
Whose
court.
income?
Matthew's income.
And the document is what document?
It's a list of his sales and commissions from the company where he was working as a salesman from 2018 till 2020. And he actually, this is our first time being in court regarding this child support matter since 2019 when it was first ordered. So it is relevant because it's showing, it shows that he has the ability to pay because
Shows he
he's
has
working.
income. The document shows that he has income.
Correct.
In 2020 from a past job. This is for contempt since December of this year. So I feel like there's no relevance.
Well, let's
Illustrating
look, hold on. Court enforcement, what's the period of time alleged under this contempt?
February 9th, 2021 to June 1st, 2022.
Okay, the objection sustained. It's ID only. Hand it to my marshal, who's going to hand it to my clerk. The period of time is from February 9, 2021 to 6/1/2022. The objection sustained. Not relevant as the period of time. Next document that's
The
challenged.
next matter is, or I'm sorry, Your, the next number is 34.
What's the document?
I'm sorry.
Identify the document for me.
You want me to, I don't understand, mirror.
Ms. Murrow, identify the document for me.
Appears to be a text message, Your Honor.
Okay, sir?
The objection is relevance. This has to do with signing up Angelina for support.
You claim him?
So in this one, it is relevant because it shows that he's lying about his income and financing.
No. The court determines credibility as to the document itself. Why are you
So
offering
it's
the document?
in the document, he's stating that he will not pay for any of the needs for our child. It's relevant because it shows refusal to financially support the child in any way.
Between the period of time of February 9, 2021 and 6/1/2022?
Correct.
It shows, it's a discussion about signing up for support. It has nothing to do with me saying I'm not going to pay for anything.
Okay. The objection sustained. ID only. Give it to my marshal, please. Sustained as to relevance.
Thank you.
Next document, please
The
identify.
next one is number 40, which appears to be an email exchange between the parties. That was 34, but just went forward. This is
Okay.
number 40.
Okay, I'm sorry.
What's up?
Thank you.
Basis of the objection, sir?
40 was the relevance on this one. This also has nothing to do with this case.
You claim him?
May I please see the document? So this is relevant because it refers, in this communication exchange, he refers to child support as an extra money for him. He claims his bills are more important.
You can't read me the document. You have to make me an offer as to why the document may be relevant over his objection to the document.
It shows ability to pay. And it's also relevant because it shows bad faith, and it shows the ability to pay and willingness only to under forced by the court.
And your objection again, sir? As
That's
to the
not,
document?
that's not what it shows, but I guess put it in and we'll go through it after.
No, we don't put it in, go through it after. We do it now. You have an objection
It does not show that. That's so I hold my same objection.
as to its relevance?
That says relevance.
Sustained. ID only. Next document identified,
Number
please.
41, which is another email exchange between the parties.
This isn't between the parties, so my objection to this is hearsay. This is between her and someone else.
I apologize, Your Honor. It's an email between the plaintiff and a Fred Anthony.
That would be hearsay. The objection sustained. ID only.
Next is number 42, which is a text message exchange.
Thank you.
This is the same objection as before. It's about the soccer, signing her up for soccer. Same objection, relevance.
It's not the same, it's actually a different document, and it's showing his ability to provide and pay.
Does it deal with soccer or signing her up in?
He states, it makes
Don't
statements
tell
in
me
here,
what he says.
not just soccer, not just soccer.
You cannot read me the document.
I'm not reading, I'm just stating it does state, he makes statements in there which show his ability to provide for and pay for the child.
Okay. The objection sustained. ID, please. Next document.
Number 45, which is another email exchange between the parties.
relevant to this one.
What's the basis of your objection as to relevance?
It's me asking her to come for dinner back in April.
Ma'am, your offer?
It shows the ability to pay.
How does that document show an ability to pay?
The fact that he's asking for dates with me is showing that he can afford to provide dinners is showing ability to pay.
The objection sustained. ID only.
Thank you.
Next document.
Number 46 is an email from the plaintiff with the Our Family Wizard.
The objection is relevance. This is just an email for the sign-in for the app that was court-ordered to set us up for.
It shows his ability to pay and the fact that he paid for this app, which is over $200.
I was court-ordered to pay the fee.
The objection sustained. ID only. Next document.
Number 66, which is an email exchange between the parties.
My objection was relevance to this. It's her asking me if I care about her and if I should be taking care of my baby mama, which is what she
Call for
said.
please, ma'am.
The full exchange is not the entire thing that we're focusing on in this. It's only certain parts of it where he references the ability to pay. And he documents in there his ability to pay. And
Okay. The objection is sustained. ID only. Marshal, you take that document, bring it up to my clerk, please. Thank you, sir.
The
ID only,
last,
Mr. Clerk.
You got it. Thank you, Your Honor.
number 71, which is another email exchange between the parties.
Yeah, objection to this was relevance. This is about visitation. Us.
it's relevant because it shows bad faith. It shows he's also lying about his address.
Court once again determines credibility, ma'am. What's the purpose of the proffer of the document?
Stating he will not pay unless forced in court.
Okay, the objection sustained. ID only. Marshal, please. Thank you, sir. Any other documents that were challenged?
That's all that they were able to get through, Your Honor.
Okay. Any other documents that you're offering today, ma'am?
Yes.
What are they?
Should I give them to each
You have to
one?
identify the document,
So this
ma'am.
one is,
You have to make the proffer to the court. You have to show the exhibit to the opposing party, and then we determine on whether or not there's an objection. How many further exhibits do you have? As the court has given you 3.5 hours to pre-mark your exhibits.
9.
Okay, identify them. One
Okay,
at a
this
time.
one is an email exchange between the two parties, and it's relevant to this because it's showing that he's stating he will only pay if forced.
Show it to the gentleman.
This is fine.
Want to be heard on that, sir?
What's that?
You want to be heard on the document being offered?
I said I have no objections.
Okay. Full exhibit, Mr. Clerk.
You got it, Your Honor.
This is number 77.
77, thank you.
Next document, ma'am.
The next document is a paid in full invoice that the defendant showing that he paid for ads that he purchased from my business and showing his ability to pay.
Objection relevance is from last September.
It's within the time frame.
You claim it's not within the relevant time, sir?
Yeah, the relevant time was from December 2020 or February 2022.
February 9, 21 to June 1, 2022.
Oh, February 2021. Oh.
Yes, sir.
Then, yeah, that's fine.
Okay. Without objection.
Fully around.
Full. Thank you, Marshal.
78.
Thank you.
Sir Marshall.
Number 79 is another paid in full invoice showing his ability to pay for his business advertisements.
That's fine. It's
Without objection,
no objections.
full exhibit.
79?
Correct.
Full, Your Honor.
Thank you, Marshall.
You, sir.
Next document, please.
So the next document is an email exchange between the two of us in which he's again stating he will not pay unless forced in court.
This is fine.
No objection, sir?
No objections, Your Honor.
Full exhibit, please.
Thank you, Your Honor. Number 80 for the plaintiff, Your Honor.
This one is Exhibit 81 is an email exchange which also demonstrates that he's unwilling to pay unless forced in court, as well as lying about his address.
Objection. There's nothing here about me willing to pay. This whole thing's about me living somewhere else.
There is, you just didn't read it right.
Do not argue with each other. You don't have the privilege. The court is not giving you the
Objection relevance on this one.
Relevant, sir?
Yes.
Proffer, ma'am?
So this is relevant because in this, he is stating that he will not pay unless forced in court, and also he's lying about his address, which he's required to report for child support.
Okay, the objection sustained. ID only.
ID, Your Honor. Thank you.
This is another email exchange from March 13th, 2022, in which he states he will not pay anything unless forced to in court.
This is no objections. Sorry.
Objection, full exhibit.
Full, Your Honor, at 82. Thank you.
Number 83 is an email communication from March 13th, 2022, in which he is showing his ability to pay and refusal to pay unless forced in court.
No objections.
Objection, full exhibit.
Thank you, Your Honor. Number 83, Your Honor. Full 83. Thank you.
Number 84 is email communication from March 9th, where the defendant is again refusing to pay and showing his ability to pay.
Objection relevance. There's nothing here showing my ability to pay, just like all the other ones.
How about your admission?
I don't understand.
Your admission, sir.
Oh, I'm being unable to pay?
What's the proffer, ma'am? Please listen to the proffer, sir.
Yes.
I'm sorry.
What's the proffer? What are you claiming the document
I'm
is?
claiming in here
It's an email.
it's an email, and it's between the two of us on March 9th, and in this, he refuses to pay child support and shows the ability to pay child support.
So as to the objection, as to the ability to pay, that's sustained. How about the admission that you're refusing to pay?
There's no objections to that.
Okay, then it comes in full exhibit.
You got it, Your Honor. 84.
84.
Thank you, Dawn.
Any objections overruled?
Thank you, Your Honor.
So on Exhibit 85, it's an email communication from April 19th between the two of us, and it's relevant because this is showing his ability to pay and refusal to initially pay.
Objection, relevance again, or irrelevance because it doesn't say any of those things. This is discussing our phone call with each other, and then
So you're claiming it's not
it
relevant,
discusses
sir?
about the party. It has nothing to discussing about child support
You're
itself.
claiming it's not relevant, sir?
It's not relevant.
Okay, proffer, please.
So it is relevant because it shows that he was lying and initially
No, the
refused.
court determines credibility.
I'm sorry, it shows that his initial refusal to pay for the parenting app, stating that he has no money and can't afford it, even though he then did pay for it after the police gave him an ultimatum to either pay for it or be arrested if he contacted me outside of the app.
Okay, the objection sustained, marked for ID only.
Thank you, Your Honor.
Not relevant.
ID 85.
Thank you.
Thank you.
86 is an email communication between the two of us from March 7th, 2022, in which it shows his ability to pay and ability to afford to have sole custody of the child.
Objection, relevance. Like, this doesn't say anything about me having an ability to pay. Just like all the other ones, it just shows me saying I can't afford it. That's not me showing I have ability to
So you're
pay.
objecting as to relevance, sir?
Yes.
Proffer, please.
It's absolutely relevant because in here he claims to be financially capable of sole custody, which shows the ability to pay.
Okay, the objection is sustained. It's marked for ID only.
You got it, Your Honor. 86 ID for the plaintiff. Thank you, sir.
Any other documents that you're offering today, ma'am?
No, but I was asking before to the clerk if it would be possible to see the exhibits that we entered before the break,
Why?
just to be able to refer to them, just so I can look at them again
For what purpose?
in case we need to refer to them.
They speak for themselves.
Okay.
Any of the testimony you wish to offer today?
Yes, actually. So I just wanted to say that Mr. Lodice has not paid a single cent in child support since that one payment he made that posted on December 6th of 2021. During that time, he has continued to work. He has continued to, he went from living in his mother's basement to getting his own apartment. He's paying his own apartment, rent, utilities. He's able to afford his lifestyle, which includes all of his bills that he's paying for his business. He continues to do construction jobs, advertise for his company. He claims he's making more money than he's ever made in his entire life. And he's been using child support as a weapon ever since it was first ordered in 2019. Every time something bad that he didn't like happened, he would threaten to take me to court. He said he would lower my child support and has weaponized it several times. He told me that he made more money from his new business that he started on April 16th, 2021. He said that he made more money than he ever made in his life. He actually begged for me back, saying he would pay all of my bills if I allowed him to move back in with me, stating he would pay me $50 a day on top of the court-ordered child support. In addition to this, he stated that he plans to tell the court that he has no income and no money. He also has shown his ability to pay by paying for other things, such as in family court, they asked us to have a joint birthday party celebration for the child and to split the cost equally. He sent me $300 that he said was for the cost of the party. He had no problem paying that. He had no problem paying for the parenting act that Judge Price Borland ordered him to pay for. However, when he was ordered to resume paying child support, which he stopped paying, he refused to even pay 1 cent of that. And I believe that he clearly has the ability to pay. When we were at the birthday party, he even took more money and tipped the girl who was hosting the party an additional $40 cash. He made payments to the child's daycare in cash, and he often gets cash deals from his job. In addition, he has people working for him, and including people who he is putting on a 1099 and paying them. He also told me that he was so busy with his work that he actually asked me to work for him, offering to pay me $17 to $18 an hour to walk up and down the street and put flyers on people's doorknobs, which is how I received the one that I submitted as an exhibit as evidence. He also maintains a gym membership. He pays his rent, 3 cell phones, 3 phone payments, 3 phone lines, Netflix, Tinder, Amazon Prime, and several other subscriptions, which he maintains. He stated to me several times in documents that I've submitted as exhibits that he doesn't have any extra money for child support, that if he has to make a choice between feeding his family and paying child support, that it's a no-brainer. He says that he'll let the court handle it, and unless forced to pay in court, that he's going to not pay me a single cent. And again, it's been almost 7 months since we received $1. I've had to rack up extravagant amounts of credit card debt just to get by, pay the bills, take care of my daughter with him. And I'm struggling financially now because of it. He owes me over $4,000 and has made zero effort whatsoever to pay it. And it's not fair to my child or to me. I do everything I can for my daughter, and I asked him to follow the court order, and he has disparaged the court over and over again, showing no respect whatsoever for the court order. And he stated that unless put in jail, he would not pay. And so I'm asking that he be incarcerated, and I'm also asking that his professional home improvement contractor license be suspended along with his driver's license until he begins making payments again. He's able to work and finance this lavish lifestyle of his, and he stated to me that he also made extreme amounts of money in the stock market trading Dogecoin as well. I have more evidence of all of this, and after getting our financial discovery, I'll be able to prove what he is making after seeing his bank statements and all of the other documents that I'm requesting, which is my legal right to see. And I just think that my daughter deserves better than this, and Mr. Lodice has disrespected the court and shown no regard whatsoever for a court order. And he stated that he cannot get in trouble for not following a court order. He said nothing will happen to him if he violates a court order. He can't get arrested. He can't go to jail. And he stated this to the New Britain Police Department the other day when they told him they would do a warrant for his arrest if he didn't bring the child to the birthday party, which was court ordered, which has nothing to do with child support, but shows the fact that he seems to think that he can do whatever he wants and nothing will happen to him.
Anything else, ma'am?
No.
Any other witnesses you wish to call?
No.
Sir, do you have any questions for her on cross-examination?
I have no questions for Amy.
For the plaintiff, sir.
No, I have no questions, but will I be able to speak and...
Your turn will come.
Okay.
That concludes your case in chief, ma'am?
Yes.
You've rested. Is that correct?
Yes.
Thank you. Your case in chief, sir?
Okay. Everything she said there was not true at all. I don't live a lavish lifestyle. I would be happy to bring you all my bank account statements, and you would see that I am struggling financially. I'm behind on my rent. My gas bill is due. It's 2 months late. I just set up a payment plan with them. My electric bill is behind. I have $200 in my bank account. My business account is negative $2. I don't have any money. I'm not sending her money or paying child support because I'm trying to be malicious in any way. All this happened because she stopped taking our daughter. This is why I applied for full custody, because she refused to take her. We went months where I was taking the full responsibility of all the parenting, paying all the bills myself. I had to sign her up for my own daycare. I had to pay out of pocket $300 a week for like 2 months until finally, just when we went to court in April, she finally started following her stay schedule. I'm doing everything I could. I've never employed anyone else. I don't have anyone at 1099. Everything she's talking about that I was doing was before I ran out of money. Like I was up to date. This is why I'm a little confused on why this contempt is from before December, because I was up to date and paid up until December. That's when I started missing my payments. That's when I ran out of money. And since then I haven't been making any payments. And I know that it doesn't look good on my part that I haven't made payments in 7 months, and I do want to make payments, and I'm going to try my best. I ask you, just please don't send me to jail or take my license, because I can't work with either one of those things happening. If you give me a chance, I will pay everything that needs to be paid, and if you could just tack on what is owed onto rearage until we could fully go through all the custody and everything, I will make sure I make my payments every week on time. It's only $4,000, which is a lot, but it's not like a large amount. It's not like $40,000 like we've heard in other cases. As far as all the evidence she provided, none of the evidence, you can go through it yourself if you want to take time to do it. All the emails are me saying, I'm sorry, I don't have the money. I can't give you the money. Or it's the discussions where I can't give you the money because I'm taking Angelina full time and I just don't have it. I send her copies of my bank statements, the negative accounts and everything. I'm doing everything I can. The times I write her over for dinner, yeah, I was able to pay for groceries and stuff like that, but I struggle. All my credit cards are maxed out. Every single credit card I have is maxed out. I can bring in those statements and show you. And all the payments were done on my electric bill or my groceries. There's nothing going out to dinner. There's nothing going vacations, nothing like that. I don't spend any money on that because I don't have it to spend on it. Everything I'm doing is for my children. I take my children 3 days a week, every single week. All 3 of my kids. I have them from Friday until Monday. And I drop them back off on Monday. So she only has Angelina 1 more day than me. It's not like I'm depriving her of her necessities in life. I am giving my daughter everything she needs. And I understand I fell behind, but please give me a chance to fix it, and I will start paying as of next week. I promise I will start paying what is owed on my child support and maintain it all the way through. Please.
Anything else, sir?
That's all I have, remember.
May I have any questions for the gentleman on the cross?
Yes, actually.
In the form of a question, please.
Okay. Why do you say multiple times that paying child support is an option for you? What is the court order?
I never said it was an option. I said if I have the option of eating or paying child support, what am I supposed to do when Angelina's sat down with me and I can't afford the groceries because I sent you the money?
Next question, please.
In Exhibit 40, you refer to child support as extra money, and you claim that your bills are more important, and child support can only be paid if you're forced in court. Is there a reason why you stated that?
Number 40 was what? Say that again, please. I said it was extra money.
Is there a reason why you referred to child support as extra money when you stated, I don't have any extra money to pay child support to?
I wasn't calling child support extra money. What I was saying is I don't have any money outside of my living expenses at that time to give to you. I wasn't saying child support is just extra money. I was saying I don't have the money for it.
Next question, please.
Why did you state in Exhibit 24 that after you were first served with your contempt in November of 2021 that you were going to then go back to court to lower the child support?
Because I had to. Because when we agreed to this agreement, I agreed to 120. That wasn't based on my income. That was based on what I thought I could afford at the time. This is when I was working for the last company. I was making good money then. That's why I agreed to that. But then I got fired. I won't say why. And I am not making that money. You can look, I would love to print my bank statements for the last year and just show the
question, please.
Why did you state in court, in this courtroom in 2019, that you were making only $8,000 a year, and now you're stating that you were making very good money at that time?
I never stated I only made $8,000 a year.
You did, and I'll get the
Next
transcript.
question, please.
Next question is, Why did you state in Exhibit 25 that you're not paying unless forced by a court?
I'm saying because I can't afford to pay you. Like, I can't just send you money. I couldn't. I could now. I'm getting there.
Okay, next question, please.
How are you able to afford the parenting app, the birthday party, daycare costs, the $70 you said you spent on a backpack and other things for the child, and all of the other documented things that you've paid for in the last 7 months if you claim to have no money?
The parenting app that I was court ordered to pay for, that the police told me I had to pay for it right away, or they were gonna get me in trouble because I'm just trying to communicate. The whole time before I paid that parenting app, I was trying to explain to you I couldn't afford it, that I didn't want to have to pay for it. Let's use a free one. You go like, no, you have to get the one you pay for. So I still paid for it. And yes, but I was court ordered to split half the birthday, and I sent you what I could, which was $300, and you still got mad at me and asked me for more money that I didn't have. I'm not paying you, Theo, because I'm trying to hurt you. I'm not doing that. I just don't physically have money. There's $200 in my account, man. That's it.
Next question, please.
Why is it that when Judge Price Borland ordered you on April 12th, 2022 to do all 3 of the following, the parenting app, re-engage in paying child support, and pay the birthday, that you feel that child support was not important, even though all 3 of those things were court ordered? Why did you feel that you could choose to deliberately refuse to pay child support when that's been 2 months now and you were warned by another judge? Why did you think it was okay
I
to pay?
didn't choose to refuse. I had 3 different things I had to pay for. I paid, all 3 were court ordered. I had to pay for all of them. I paid what I could.
Is there a reason why you paid 0 towards the child support, which you were also court ordered to pay since?
Because I don't have the money.
If you didn't have the money, how are you able to pay for the other items?
I had $600. What should I give you nothing and then just pay the child support? And then you'd be here saying, oh, he didn't pay for the birthday, he didn't pay for this, and those are court ordered. So like no matter what, it was a lose-lose situation.
It shows your ability to pay, does
It
it
shows my
not?
ability to pay well.
It shows that you have the ability to pay for extra things, does it
Excuse
not?
me. You don't get to argue with each other.
I'm sorry.
You ask a question, you answer it, sir. You move on to the next question. Next question, please.
How are you able to make the payments that you've been paying for Angelina's daycare in the past few weeks, despite you claiming that you have no money to pay your court-ordered child support?
Because of you have the care for kids, it's $19 a week. Yeah, I can scrounge up $19 a week pay for a daycare. That's a lot different than paying you $120 plus $4,000 in arrears. That's a huge difference.
According to the teacher, you paid a $40 cash payment last week.
For 2
How are
weeks.
you able to get that $40 in cash?
I'm working.
So you're working.
I never said I wasn't.
Okay. So you're working and you have the ability to pay, correct?
I do now, yes. This is why I said I will start paying. If not, then you can send me
No
the jail.
questions pending. Next question, please.
Next question is in Exhibit 28. Why did you state that you were refusing to pay and blatantly refusing to pay despite having the ability?
I think that was objection sustained.
This was actually okayed and it was not objected to.
Yes, it was.
28, please, Mr. Clerk.
28 is a full exhibit, no objection, Your Honor. I have it right here.
Thank you.
No objection?
No
You have what you
objection.
said.
What did I say in it?
Why in that exhibit were you refusing to pay your court-ordered child support as well as admitting to blatantly refusing to pay despite having the ability?
When you say despite having the ability, what does that mean?
No, you don't get to ask her questions.
Because
Answer
I
the
didn't
question
have
she
to.
asked of you, sir.
Because it's not, I wasn't refusing because I wanted to. I was refusing because I didn't have the ability. You can't just say I have
Thank
the
you.
ability.
Next question, please. Court determines whether or not you have the ability,
I
sir.
apologize, Your Honor.
Next question.
Why in Exhibit 29 did you state that you were blatantly refusing to pay unless forced by a judge or court?
Objection said and heard and said already. It's the same question she asked.
29, the full exhibit, or is it 27? It's 29?
That's 29, Your Honor. Yep.
29 is the full exhibit, sir.
Yeah, but she's saying that she's asking the same question she just asked. She's saying, why am I refusing to pay? Saying I'm refusing to pay when I'm explaining I couldn't afford it.
And you object to her asking the same question over?
Yes.
Asked and answered, the objection sustained.
individual named Tom Salvador of the Gill Foundation at 115 Waterbury Road, Prospect, Connecticut?
Yes.
And did you perform a roof for that business?
Yes.
And how much did you get paid for doing that roof job?
For the whole job or for my income based on it?
How much did you get paid for doing that roof job?
I think the whole thing was, I'm going to say 11 or 15, 7 done.
Just to clarify, you said you were paid $15,000 for that job, correct?
For the whole project.
Excuse me, just to clarify, you were saying you paid $15,000 for that job?
Yes.
Correct. You received $15,000, and when did you perform that job?
I want to say last June. I don't know.
According to this individual, you performed this job in 2022.
That's not true.
So when did you perform the job?
This was at least a year ago.
Okay, so seeing that it's within the time frame where we're discussing for this contempt from February 2021 to June 2022, is there a reason why you received $15,000 for doing a job and still felt that you could pay $0 in your water child support? Is there a reason why you still felt that you could choose to pay $0 when you're making $15,000 off of one job?
That time that job was done, my child support was being paid. And you can look that up. You can correlate the days with each other, and that was being paid. I stopped paying in December.
Is there a reason why? Is there a reason why you were telling the court that you are indigent when you were making over $15,000 for each job that you're doing, and still refusing to pay your child support, which is court ordered?
That time, when I made that money for that job, my child support was being paid because I was making that money on that job. When I make the money, I do pay it, Theo.
And how many cell phones do you have under your name in T-Mobile?
There's 3 lines on my cell phone.
And you pay for 3 separate lines as well as 3 separate phones, correct?
The phones are bought and paid for. Mine are both 3 years old.
So you were able to pay in full for 3 phones and
Yes, 3 years
continue to
ago,
pay
yes.
the lines on 3 lines. And are you late on your cell phone right
I am
now?
late on my cell phone.
But your line has not been suspended, correct?
No, because I'm
None
on
of
a
your
payment
other
plan.
lines?
I'm on a payment plan.
And what makes you think that paying for 3 cell phones, not 1, but 3 cell phones, is more of a priority than the court-ordered child support for our young 3-year-old daughter?
Well, I need more my phone for my business. The other one I'm actually removing because I can't afford it. And to add on the extra lines, it's $10 a month.
So during this last 7 months, at no point did you think to remove the 2nd or 3rd line on your phone in order to be able to pay your court-ordered child support for our young daughter who needs food and other necessities? At no point did you think that maybe paying the court-ordered child support was more of a priority than the 3 cell phones?
I guess I did not. I'm sorry.
So according to you, you having 2 cell phones and your 14-year-old son having 1 cell phone is more important than our daughter getting her court-ordered child support paid?
No, that's not what I think.
Then why didn't you pay it?
Because I was trying to pay all my bills and then pay that.
So which is more of a priority in terms of your bills, the 3 cell phones or the child support?
Well, at least my cell phone, because I need it for my life and work. How can I communicate with you through an app if I don't have a cell phone?
Which is more a priority, 3 cell phones or paying the court-ordered child support?
Obviously, the court-ordered child support.
So why haven't you paid a single penny of it in 7 months?
I just haven't been able to.
But you've been able to pay the cell phones, multiple cell phones.
So what am I supposed to do? Not have a phone and just pay you?
Why do you need 3 phones?
I have 1 business line, my personal, and then the other one's Dominic's. That cost me $10 a month to add on the line.
How are you able to afford those if you're claiming that you only make $400? How are you claiming to afford those if you say you only make $400 a week and you also pay rent and you also stated that you pay $20,000 a year for food and gas? How are you able to afford it?
And everything. Look at my credit card statements.
In the last 7 months, how many months have the cell phones been shut off for non-payment?
In the last 7 months, probably twice.
And in the last 7 months, how much have you paid in child support?
I have not paid anything in 7 months. We just discussed this.
Okay. And do you currently have a gym membership?
I bought a year membership last year without having money.
And so you thought that paying for a full year membership for your
At that
personal
time,
gym
child
was
support was
worth it?
paid.
That's not true.
Yes, it is.
Okay.
Do not argue with each
Sorry.
other. This is question, answer.
Okay. And why did you leave from your mother's house at 48 Quarry Hill Road, Waterbury, Connecticut in December of 2021, which you were having a free place to live?
Because when I was taking on the full responsibility of Angelina, it was becoming too much for her, and she wanted me to go.
Okay, so how are you able to afford rent and utilities for your new apartment that you got?
I struggled. I stopped paying child support and I used my money to get a place because I didn't want to live on the streets. So I should live on the streets and pay child support.
So you deliberately stopped paying child support because you felt that you getting your own apartment was more of a priority than paying your court-ordered child support?
Yes, I felt that providing shelter for my children and me was more important. Yes. Yes, I
Oh,
did.
okay. Even though you have multiple family members who would give you a place to stay, such as
No,
your
I don't.
father, your mother, your sister, either of your brothers. And is it also true that your landlord is actually your sister-in-law's brother?
That was the only reason I got the place.
Is your landlord your sister-in-law's brother?
Yes,
or
of
no?
course.
Okay. And how much does he charge you monthly for rent?
$1,000.
And you're able to afford $1,000?
Well, I'm behind now.
Okay, so you've stated that you are paying $1,000 a month for rent.
Right?
How much are you paying for the cell phones?
$200 a month.
$200 a month for 3 lines, and you're able to provide documentation of that?
Yes, I can.
Your bill
It's
is
like
$200 for 3 phones?
Ask you a question, ma'am.
Yes.
Okay, and you also stated that you're paying another $2,000 a month on food and
Yes, I have the
gas.
whole thing, you know.
How are you paying for any of this with no income?
Please stop when I interrupt you. Thank you. It's question and answer. Do not talk over each other. I have a court reporter who's taking this all down. If you talk together, she's not able to do so. Thank you. Ask your question.
So, what source of income do you use to cover the $4,000 to $5,000 per month that you stated in your financial affidavit and in court and in documents that you pay monthly for yourself to live? What income do you use to pay that?
I did not claim I paid $4,000 a month in bills.
Did you not just say that you had $1,000 a month rent?
Yes.
And did you not state that you pay $150 a week in gas and $200 a week in food?
Yeah, food varies, but yeah, I would say that.
And did you not also state that you pay $200 a month for 3 cell phones, which are unnecessary?
That not unnecessary, but yeah, okay.
So you believe that a 14-year-old having a cell phone is necessary?
Okay, I could take your cell phone off and save $10 a month and I can send an extra 10.
Next question, please.
How are you able to pay the $1,000?
I haven't been. This is why I'm negative. Look at my accounts. There's
Next
200.
question, please.
My question is, how in the past 7 months have you been able to pay the $1,000 a month for rent, not including the utilities, in addition $150 a week for gas, $200 a week for food, and $200 a month for the phones, and all of your other expenses? How have you been able to do that with what income?
With the money I've been making, working.
So if you stated that you're making $400 a week working, how does that allow you to pay?
It's like $1,600 and I rack up a lot of credit card debt. All my credit cards are maxed out.
You stated you
I
had
hit rock bottom.
in your financial affidavit, you stated you only have 1 credit card with a balance of $3,500. So
That's all my credit cards combined.
none of that adds up. How does any of that add up to this amount here that we just stated?
Because when I didn't have money, I borrowed money from people a few times.
And why didn't you ever think to borrow money from people to pay the court-ordered child support?
Because I was borrowing money to get by.
So you don't think that our daughter, who is with me from Monday, you drop her off Monday at before 9 a.m., and she goes to your mother until you get her on Friday evenings. So
And
do you
not
really,
Friday,
do you
she goes
think
my
that,
mom.
no, she doesn't go at 9 a.m.
Please don't argue with each other. Ask your question.
Do you think that
Otherwise, I'm
our,
going to admonish you. And then I'm going to sanction or fine you for not complying with the court's instructions. Ask a question.
do you think it's fair that our daughter, who is with me more than 75% of the time, should not get a single dollar of support from you at all?
No, I think it's not fair that the 1 day a week that you do have her more than me, that I do not pay child support to you. I'm sorry that I haven't. I don't think it's fair. I
And
think
how-
it's wrong. And that's why I'm trying to say I will start paying it. It took me a while to get, level. I had to move out of my house. I had to get my own place. So, no, I don't think it's fair that you're not getting your child support. I don't. And I want to pay you. I do. I'm not paying you for any reason. It was hard for the first 6 months those 6 months before April when you weren't taking her and I had the full responsibility. And I can pay now. I'm at a point, it's summertime, season picked up, I'm starting to get some work, I got some jobs coming in next week, so I'll be able to pay coming next week. This is what I was telling Your Honor, that I would start paying next week and I will maintain payment every week consecutively.
Did you do work at the address of 23 Lyman Road, New Britain, Connecticut?
Before I moved in there, I worked on the apartment.
How much were you paid for the work that you did on that address?
I wasn't paid. It was kind of like a little deal we worked out for me to get into that apartment. So the reason I got a nice
No question pending. Move on.
Okay.
Okay. How much did you get paid to replace the roof for James Lambo in Middlebury, Connecticut?
I never did chase her.
You stated
Form of a question, please.
how much did you get paid to replace the roof for Greg Gallo?
I never did Greg's roof.
I have proof that you did.
Ma'am, you don't get to make statements. Ask your question.
Do you currently have internet at your house?
I do.
Do you currently have Amazon Prime at your house?
I don't.
Do you have Netflix at your house?
I use somebody else's account.
Whose account do you use?
My girlfriend's.
Okay, so who pays the internet?
She does.
Okay. And at any point, did you think to ask her to maybe borrow some money to pay your court-ordered child support for
I borrowed money to buy
getting
gas and
incarcerated?
groceries 2 weeks ago, and I could show you where I did that.
Okay, so you get additional income from your girlfriend.
It's not
and-
income. Me borrowing money from somebody is not income, Theo.
Okay. So does your girlfriend give you money, yes or no?
Has she or does she? Those are two different questions. Has she? Yes. Does she? No.
So you're objecting to the form of the question?
Yeah, objection.
Sustained. Ask the question again.
Has she given you money in the last 7 months?
Yes.
Have you used any of it to pay your court-ordered child support?
No.
Do you respect what a court order is?
100%.
Why did you not pay any child support after April 15th when you were given a final date to pay by Judge Price Borland?
Because after everything I was paying for, trying to make sure I can maintain a place, feed the kids that I have 3 days a week, like I said, and make sure I can still maintain work by having gas in my car, I didn't have the money.
So you think that your gas in your car and other things like your other bills are more important than this court order here?
It's not that I think they're more important, but I think that for me to survive, yes, I do need to pay those bills. I need to have shelter. I need to have food. I need to be able to work. Like, if I don't have those things, I'm going to be living on the street. Am I supposed to live on the street just so you can get your child support for the 1 extra day you have her? I'm sorry, I couldn't.
How are you able to pay your car payment monthly?
Well, it's behind 2 months right now, about to be 3 months, which I'm kind of nervous about. And 3 different times in the last 7 months, I had them push my payment to the end of the loan because I couldn't afford it. And I can bring documentation for all this. I'm not paying you, Theo, because I'm trying.
So in the last 7 months, you were nervous about missing a car payment, but you weren't nervous about missing your court-ordered child support payments.
I was nervous about them taking my car and losing my ability to pick up my kids, to bring them to daycare, to school, to be able to work. Yes, I was nervous about that and sending you money.
And you weren't nervous about getting incarcerated or possibly having other sanctions placed
I
upon
was
you
scared
for
of
violating
incarceration.
court order?
I don't want to go to jail.
And is that why you didn't pay a single penny in 7 months?
I don't understand the question.
If you don't want to go to jail, why didn't you pay a single penny in the last 7 months for child support, which is court ordered for our child?
Because I didn't have the money. You keep asking the same question. I don't have it.
Is it that you didn't have the money or that you just chose to allocate the funds to rent, car payment, 3 cell phones,
Well, I guess to answer
Amazon
that question,
Prime, internet,
I
and others?
allocated it to my other bills, my primary bills, yes.
Okay, so in your mind, your primary bills supersede a court order.
No.
So why didn't you pay the child support first, which is what you were ordered
Because
to do?
maintaining a shelter had to be done first. I need to have a place to live. Why don't you just let me start paying now and let them add on a
Question
risk?
pending. Move on, ma'am.
Why didn't you include your business checking account on your financial affidavit?
Well, one, business checking is not my personal account, so that's like a separate entity. And 2, it's negative $3 right now. But I can be happy to pull that up if you want to see it.
How were you able to afford the $70 that you claimed to pay for a backpack and other items that you bought for Angelina for her first day of school?
On her first day of school, I had to buy her things. Because you refused.
How were you able to afford it?
I told you, I had some money. You keep going around the same
Next
circle.
question, please.
So you're admitting that you had some money and that you've had access to money throughout this entire period of time, yet you didn't find it necessary to even pay 1 penny or make any effort whatsoever to pay the court order. You continue to just let it add up. Is that correct?
It is correct that I let it add up, yes.
Okay, and how much did you pay for those glasses that you're wearing?
These were free. They're state funded. Husky.
Husky doesn't pay for Nike.
Ma'am, once again, it's an
I'm
argument,
sorry.
and you've been admonished. And if you continue to make that argument, I'm going to cut you off on cross, and you'll be concluding. Ask your next question.
If you are
Answer your last question. My sister works for the ISO.
Stop talking.
Okay, sir.
So, did you or did you not offer and actually pay me to work handing out flyers for your business?
Yes, I did.
Okay, and how were you able to afford to pay me $18 an hour to hand out flyers if you claim to have no money?
Because back then I had money and child support was paid. This is when I was still paying child support. This was last summer.
And who is Gabriel Mina?
My friend, a neighbor that I grew up with,
Okay, and has he or has he not worked for your company?
he does not work for my company.
Okay, so when the police were involved, when he was threatening me, and we actually had police statements, then they spoke to him, you stated in the police report that he was your employee. Is that correct?
That's not correct.
So you're saying that you lied when you made the report?
I never said he was my employee. Show me where I said
So
he
he
was my
never,
employee.
so,
Once again, you don't get to argue with each other.
Oh, I'm sorry.
It's an ask and answer.
so are
If this
you,
continues, I'm concluding your cross, ma'am.
Oh.
Move on.
so who does the work for you?
Me?
So you're saying you complete roofs on your own by yourself without any help?
I did one.
So who has done all of the work for you in the last year?
Me?
So you're saying that you do all of the work, complete roofs, and all the other home remodeling projects by yourself without anybody else working for you?
I have that many remodeling projects.
So when you got paid $15,000 to do a roof, you did it by yourself?
Yes.
So if I ask Mr. Salvador, he will state that no other workers came to the Gill Foundation to do that work other than you.
Yes.
Okay. So why in Exhibit 30 did you state that you would pay support enforcement and not me? However, support enforcement states that you still haven't paid anything.
Because you kept asking me to send you money. You said, send me the money, send me the money. Don't worry about support enforcement, just send me the money directly. And I said, no, I'm supposed to pay support enforcement, not you, because that's what they tell me to pay.
Did Judge Price Borland tell you in court that Zelle was an option for paying?
If it wasn't court-ordered to support enforcement. Zelle was an option for me to pay you for the babies, or for the party. It was never an option for the child support.
And so did you or did you not acknowledge on April 12th, 2022 that you were required to pay that $120 a week order no later than 6 p.m. on Friday, April 15th?
Objection, asked and answered.
Sustained. It's all part of the court file. The court has read it into the record. Court takes judicial notice of Judge Borland's order.
Noted, Your Honor.
Why in number 51 did you originally say you were only able to afford $200 for our child's birthday party, but then decided that you were going to pay $300? Does that not show that you were refusing to pay an amount and showing that you're actually able to pay more than you were initially offering?
That's me showing that I'm struggling. I only had $200. I didn't even have that to really send. And I said I would give you $200, and you kept fighting with me about it, saying that, oh, then we're just going to do the party without you. We're just going to, you need to send me more money than that. So yeah, I came up with $300, and then I had other bills that were behind.
You originally stated you wouldn't give me any money and that you were only going to send it directly to the venue. However, you then stated you would give $200 and you then stated you would make it $300. So does that not show the ability to pay child support if you were able to afford an additional $300 for an extra expense of a birthday party?
No, it does not show that because it was court ordered for me to pay half. And you were telling me it was going to be at least $600. So no, that does not show that.
And was the child support court ordered?
It was also court ordered, yes.
And so
They're both equal court orders.
if they're both equal court orders, why did one get ignored and deliberately disobeyed?
Because I had to pick which one I could afford. I had $300. It was either pay the baby, pay for my daughter to have her third birthday party, or pay some back child support. I chose to pay for her birthday party.
So do you think that our daughter deserves to eat and have a roof over her head?
Of course, that's why I'm struggling so hard to make sure she has that when she's with me.
So I have primary residency of her, which means she's with me majority of the time. Do you not
One more day.
think that it's important for her to eat and have a roof over her head?
Of course I do.
And so do you not think that the $4,034.47 that you owe is by you not paying that? Do you not think that that hurts our child?
I think it does hurt you a little bit to not get that extra income, but I think you also do very well contrary to this statement.
My question was, do you think that hurts our child, yes or no?
I do not.
So you think that you not paying me a single cent in child support since November, when you made your payment, which posted on December 6th of 2021, you think that by not paying a single cent that it doesn't hurt our daughter at all?
I know, I do. It's not that I don't think it doesn't hurt. Yes, I think it doesn't hurt her in any way. I think it may hurt you a little bit financially that you're not getting the extra income, yes, but I don't think it hurts her directly.
Okay, and if I was unable to pay my mortgage and we had to go on the street, would that hurt our daughter?
I would never let that happen. I would let you guys.
How would you not let that
I
happen?
would have you move in with me.
How can you afford to have us move in with you if you can't even afford to take care of yourself?
I would struggle like I have been.
So how would you struggle in order to
Objection,
make
relevance to all
money?
this question.
Sustained.
Second.
Any other questions on cross?
No.
Any redirect by you, sir?
I just want to say that I will try and I will make sure I pay every week from this point on. But if you take my license, if you send me to jail, I can't do that from in there, and I can't do that without being able to operate. So please give me a chance, sir. I've never been behind on child support until the end of last year. It's the first time this ever happened. I have child support with my ex-wife, and in 8 years, I've never been behind. And then finally, at the end of last year, I fell behind a lot. I'm finally at a point where I'm level. I'm a little bit behind my bills, but I have enough to skate by where I'm going to pay the child support any way I could.
Okay, anything else?
No, Your Honor, that's it.
Any other witnesses you wish to call today?
No, Your Honor.
Okay. That concludes your contempt, ma'am? For support enforcement? Number 136, correct?
Correct, Your Honor.
Thank you. And the order is 120 a week?
Correct.
And the amount of the arrearage found is $4,034.47 as of May 24, 2022, and that's owed to the petitioner. And the court will order $24 a week on the arrearage payment. The income withholding is modified accordingly. That's effective today, 6/1/2022. Your order is now $44 a week, sir. $120 a week on the current support and $24 a week on the arrearage. Court and how do you pronounce your last name? Lodice?
Lodice.
Lodice?
Yes.
Court finds that Mr. Lodice is subject to a court order. The court order is $120 a week. The court again takes judicial notice of Judge Claw's original order and also Magistrate Price Borland's orders that he begin paying his child support again. And the court finds that the order is valid and unambiguous, that the gentleman had knowledge of the order, failed to pay the order between the period of time of February 9, 2021 and June 1st, 2022. Number of weeks that exist for me, madam?
I'm sorry,
Is
was
that
it April,
18 weeks?
April 15th?
I believe it's February 9, 2021.
Oh, I'm sorry. February 9, 2021 to June 1st of 2022 is 68 weeks.
And from Price Borland's order to today?
The PD was to start April 15th to today's date, June 1st, which would be 6 weeks.
6 weeks?
Yes.
Thank you. Find that he had the ability to pay and comply with the order, and this failure to pay the order is willful and a clear and convincing basis under Brody. Find that the gentleman is found in contempt of the court order, and he's ordered to pay a purge of $2,160. Do you have the $2,160, sir?
Not, Your Honor.
Okay. The gentleman is remanded in his custody of the Department of Corrections on the payment of the purge of $2,160. Purge is not paid, the gentleman will be remanded, and his review date is June 29th,
So what does that mean?
2022, and if the purge is paid, the contempt is concluded. You're required to pay the weekly order each week on time in full. The order is now 144. Marshal, you may take the gentleman into custody.
So does that mean I have to hold it out until 2008?
Date of birth is May 11th, 1983.
Thank you.
Is this? Yeah, sorry, I wrote that. That's not. So now, do I have to stay in jail until I come up with $2,000 out of the night?
2,160.
If I don't come up with that money, I just stay in jail?
You stay in until the review date of June 29th when the court holds a review on the purge.
So how can I work and pay money?
Take the gentleman into custody.
Makes no sense.
And so you're in the motion to modify date stays as the July 11th, the special hearing date for the modification.
Oh, it's already scheduled that?
Yeah.
2 p.m.
For number 148, it's 7/11, 2 p.m.
And the court stays adjourned, Marshal.
Thank you.